get started in about 2 minutes. In 2 minutes, we are going to get started with the forum. And if you have, there's a sign-up sheet in the back. If those persons that want to participate in the questioning, we ask that you also sign up on the sign-up sheet. Amen. For the last 12 years, we are part of the settlement agreement and with the enhanced amicus status that was given to us by Judge Simon. And this is a very, very vital issue to us and to the community in general. Today we'll be focusing on changes within the structure of review of cases by the um, police review, and we will focus on that particular structure in particular. Now, there are some housekeeping matters that we need to talk about. There are restrooms that are in the foyer in the back. And the men is to my right, as well as a water fountain, and then the women's restroom is on the left side. And so if you have to use the restroom, we ask that you will make note of that, as well as the drinking water fountain. We also want to remind you that this is a church and we don't use profanity here, okay? And we want you to keep the sanctity of the church building in the same. We are engaged in this struggle, and we were one of the stakeholders that asked and requested that another forum be given as an opportunity for input to take place because of the quickness of this matter. We felt, along with many other stakeholders, that there was a great need for another opportunity for the community to give input to this matter. And so at this particular point, the panel will make their presentation, and following their presentation, we will do a Q&A, but we're going to keep the rules of the council of 3 minutes for the Q&A play. Over into the hands of the panel for the presentation, and if you can present the panel at this time.
panels to see if they can't get the work done in a way that is not so taxing for them, but that also accomplishes the purpose of ensuring that we've got civilian input into discipline decisions. So that track is 187 days. And probably, I think, hopefully if CRC is able to give some feedback, the 21 days for that CRC appeal process, we've definitely gotten feedback that even with panels, that may not be enough time. And so, you know, the barrier that we're up against is that, again, it's a national best practice that these complaints be resolved in 180 days. And so 187, maybe, you know, wiggle room, more doable. 190, boy, you know, that may be harder. So I'm here to hear from you all about what you would like to see given the constraints of the settlement agreement. And so I'm happy to answer any questions, and I'm going to pass it to Mark so he can walk you through some of the other changes.
Thanks, Ellen, and thank you, everyone, very much. We appreciate the opportunity to come talk and as Ellen said, get more community feedback on some of the proposals that we're looking at and trying to accomplish the various goals that we're trying to meet in looking at revisions to the Portland Police Bureau's police accountability system. Ellen has really touched on most of the highlights of the system. As she said, in trying to come up with recommendations, we're balancing a number of interests here that aren't necessarily completely compatible. For example, as she mentioned, the DOJ has said national best practice is that all complaints should be investigated and resolved within a 180-day time period. So from that aspect, an important part of the system is to have an efficient system that moves as quickly as possible, both for the benefit of the complainant as well as the involved officer. Particularly here in Portland, we realize that an extremely important value for the Portland community is also to have community oversight, community input into the police accountability system. And Portland is about process, and which is we think here in Portland is a great thing. Process takes time; it's not necessarily efficient. So that in trying to come up with recommendations for a police accountability system, we're trying to balance efficiency, speed, efficiency, against having sufficient community input into the process, that we get that into the process, but it does tend to slow things down. In developing the process, we think we've met some very important goals that the DOJ outlined in some of their comments about track, or on a more serious investigation track that's conducted either by Internal Affairs or by the Independent Police Review Division. Another important goal that we feel is met in this proposal is increasing citizen access to the complaint commendation system. That provide multiple points of access if a citizen has a complaint or a commendation they want to give to an officer. But if they have a complaint, they can go to Internal Affairs, they can go to Independent Police Review, they can go to one of the precincts, they can go to the mayor's office, or under this proposal, every police officer will have complaint forms with him or her, have those available. They can take the complaint and it will be forwarded to IPR, IPA to be documented in the system, and an investigation of that complaint will be initiated. Retain and enhance community oversight and input. Have earlier and more meaningful complainant input. As Ellen mentioned, under the current version of the proposal, the complainant would have an opportunity to appear in front of the Police Review Board, where currently the officer who's accused of wrongdoing can appear before the board and provide their side of the story, so to speak, to the board. under the revisions that we're looking at, the proposal we're looking at, the complainant would also have that opportunity, which those of us who work with this system on a day in, day out basis believe that's a very important component. Again, it's the complainant's complaint, and the Police Review Board, they are the board that makes direct recommendations to the police of the chief of police on whether or not has been a violation of policy by the officer, and if so, they also provide a recommended level of discipline to the police chief. The police chief and the police commissioner, currently the mayor, they make the ultimate decision on discipline, but allowing the complainant to come in and address the Police Review Board, we believe, provides a more earlier and much more meaningful input into the process rather than the current system where they wait until that process is finished and they can then they have the opportunity to appeal it to the Citizen Review Committee, but they would have a more meaningful input at that stage of the process. The last community forum that we had, there was discussion around a recommendation that had come out of all the work groups, the focus group that had been convened, and with input from City Council to look at a consolidated review board that would, instead of having appeals of individual officer discipline cases reviewed by the Citizen Review Committee, there would be some enhanced community involvement on that board. And the feedback that we got, as Ellen mentioned, from that last community forum and other input, was there was a strong public interest in retaining some level of public participation, at least in that CRC process, and allowing the CRC to continue to hear individual officer appeals of individual officer discipline. So under the current proposal, which is outlined briefly in the flow chart that's been handed out, I would retain the CRC appeals, the CRC review of complainant appeals in individual officer discipline cases, but it would be broken out into panels to try to expedite that process. The other significant change that Director Sevier can address in the code changes that are being proposed to council, they were filed last Friday with the council clerk to meet our timelines to attempt to have this heard by council on September 14th. Is the public participation in the appeals of individual officer discipline cases would be modified, and rather than have public comment during the CRC's deliberation of the particular case, that public comment would be reserved till the end after the CRC had deliberated and made their decision on that particular individual case. So that very briefly is a very, very rough outline of some of the changes that are being considered currently by the city. And with that, I'll go ahead and pass this on to Director Sevier.
Good evening, everybody. My name is Constantine Sevier. I'm the director of the City of Portland's Independent Police Review. I would like to thank everybody that is here tonight. Again, would like to thank AMA for its work and for inviting representatives for the city to have a conversation with community members about such an important topic. Just really briefly, the Independent Police Review is a part of the city auditor's office. The auditor is an elected official. I report directly to her. The biggest areas of IPR's work is receiving community member complaints about officer misconduct as well as commendations. We can do investigations. Currently, the investigations that we decide to do are cases where the involved officers are ranked captain or higher, cases involving people who feel that they've been retaliated against for filing a complaint against a Portland police officer, cases involving protests, vulnerable individuals, juveniles, those types of cases, as well as a monitoring function. So every case that the Portland Police Bureau decides to investigate with Internal Affairs, our office has to approve the investigation, and we also have to approve the final findings. We have the ability to refer a case to the Police Review Board. In our goals in providing a proposal to community about improving our oversight system, one of the things that we tried to make sure that we incorporated was the feedback that we've been receiving for a number of years around making sure that community members feel heard when they contact IPR. There are a few copies of IPR's annual report out in the foyer, and if you looked at that, you would notice that IPR has a relatively high dismissal rate, which is common around the country. And one of the reasons why it is common for oversight agencies, whether it's police or civilian-oriented, when they look at police misconduct cases, is there is this paradigm around whether the officer, based on a preponderance of the evidence, which is 50% plus one, whether they engage in misconduct, which is very legalistic, and you have to weigh the evidence and then you make a decision. From what I've heard from community members, people really want an accountability system. They want, if they have a concern about a police officer, that the city takes it seriously and tries to address it at the lowest level possible at the most appropriate time. And that, I think, is the heart of this particular proposal and the work that different folks at the city, whether it has been the mayor's office, city attorney's office, or the auditor's office, to make sure that community members, when they file a complaint against a Portland police officer, whether it is rudeness, it's not a matter of whether the city can prove an individual officer is rude or not, but it is an issue that that community member left a contact with a Portland police officer and they felt that they were disrespected. And that has a consequence to this city, and it has a consequence not just to the police bureau, but I think to everybody that lives in the city of Portland. I come from a city that the police, unfortunately, are not respected. They are, I think, so I'm just going to say, I'm from the city of Miami. The city of Miami, Florida, is on its, I think, has had 2 Department of Justice interventions in the last 15 years. I am glad of the role that the Department of Justice has played in making us have a better oversight system, a better accountability system, a better police bureau. But at some point, the Department of Justice will leave, and we will have to make sure that we have an accountability system that works for us as Portlanders. You cannot hear me? I apologize. I will try. I'm a little bit of a low talker, and I'm also a Southerner, so I talk slow sometimes. So the combination of a low voice and slow talking can be excruciable for some people. So I apologize. I'll try to talk louder and faster. So the goals in the accountability proposal is, one, for there to be, as Mr. Amberg noted, for there to be multiple areas for community members to provide input. And as the IPR director, I want to make sure that when because the biggest areas of complaint that IPR receive revolve around courtesy, the officer failed to take appropriate action, which are areas where I believe a supervisor would be the most beneficial person to hear that feedback, and where IPR can be a facilitator of making sure that that supervisor receives that information. We want to do that. The other really important part of IPR's work is serving as staff, as an advisory entity to the Citizen Review Committee. The CRC is a advisory body to the auditor and the chief of police, and they hear appeals of misconduct cases among some other work, and they work, the 11 members of the Citizen Review Committee work incredibly hard, and we want to make sure we support them in what they do. The 2 biggest areas that this code deals with is allowing the CRC to meet in panels so we can make a good faith effort in trying to meet the 21 days. The other part is around public comment. And this is really an important part. So the Citizen Review Committee is part of the city's attempt to make sure its officers are held accountable. So, so as background, I'm a former criminal defense attorney. I went to court a lot. I created what is called a record when you go to court. So if something happens, when it goes up for further review, whether it's the Court of Appeals or Supreme Court, that is reviewed by that body. So whenever a city tries to discipline a police officer for misconduct, that, particularly if an officer files a grievance, that is reviewed by an arbitrator, and they look at the record, which is everything from when the city was put on notice that that there was an issue of misconduct to the end. And in our system, it is the chief of police who makes that decision with the mayor. The Citizen Review Committee is part of that, and one of the issues with allowing public comment during a misconduct appeal is you're allowing individuals who have not had access to a file to make comment about whether that officer should be found out of policy or not. So, and I don't really want to get into too much of the nitty gritty, but just from a fundamental fairness, so, you know, the United States Constitution has a 14th Amendment, talks about due process. The Portland Police Association has a collective bargaining agreement with the city that kind of enshrines some of those concepts as well. One of the biggest issues around public comment and making sure that public comment is allowable at CRC meetings during kind of their general meetings where the city really wants to hear concerns that community has about police issues, but the difficult part of allowing comment at an appeal hearing is and I'm just going to speak for myself as somebody who, I haven't done employment work as Mr. Amberg has, but as somebody who has been a litigator, the city puts its ability to sustain a case throughout the whole process, including arbitration, at risk by continuing its current practice of having public comment during the Citizen Review Committee, and particularly during the appeals and the case file review. And one of the things that we want to make sure that we have is that we have a system that can withstand outside scrutiny through all of its aspects. And I think the proposal that we have here is something that when it's looked at whether in the complete package or broken up into individual parts, can do that. And I want to make sure that everybody can provide their questions and answers, so I'll kind of reduce my statements from here.
All right. We have heard the short presentation from the panel. Now, I want to confess that the AMA Coalition does have a bias, and the bias is that we support a citizen review board with subpoena power, an independent citizen review board with subpoena power. And so I want to put that out there. And so we're here like you to look, examine, and to critique what is being proposed here. And we're going to call first and second people up for QA at this time. You had a question? Yeah. Okay. We're going to take the people that sign in first, and then we're going to open it up, okay? All right. Dr. Rochelle Sibber and Dan Haldeman will go in that order, and I'm going to ask Reverend Laurie to keep the 3 minutes for me, okay?
Obviously, I'm not Dr. Silver, but I'm reading her statement. Can you hear me? All right. Dear all, I am sorry I cannot be present at the second forum on police accountability, but did want to make a few comments. As you know, I am currently a COAB member and have previously served as a member of the CRC for 5 years. I want to thank you for delaying the hearing on the initial plan presented at the August 1st forum, and I want to thank the auditor for removing some of the most serious, egregious facets of that plan. The current plan, however, has many downsides too. also. It is as or more complicated than the current accountability system, which was deemed by the DOJ to be Byzantine. It does not allow for advocacy of the complainant, appellant, and most seriously disallows the public from providing input at the appeal hearings. Having panels of only 3 CRC members to hear appeals is also a flaw, in my opinion, and should be increased to at least 4 and preferably 5 members. This can be done by increasing the number of CRC members. But most importantly, the proposed plan does not address the 2 most serious flaws in the current accountability system, and that is, it does not change the standard of review for CRC appeals from reasonable person to predominance of the evidence, and it does not give the IPR authority to compel testimony from a police officer, therefore disallowing true independence. I again urge you not to be in such a hurry. I know the auditor is concerned with being out of compliance with the settlement agreement, but in truth, the city is already out of compliance in several ways. Please look at other plans that may be totally different plans from other jurisdictions, plans that have been submitted to you already, such as the plan submitted by the Accountability Subcommittee of the COAB. Let other plans be considered in open public forums such as you are having tonight and allow community feedback. Please don't jump into another plan that will be community unfriendly and Byzantine. Thank you for your consideration, Dr. Rochelle Silver.
I don't have my back to y'all, so I'm going to move over. Okay. Hi, I'm Dan Handelman. I'm with the group Portland Cop Watch. I'm also a steering committee member of the AMA Coalition, but I'm speaking on behalf of Portland Cop Watch tonight. And Portland Cop Watch applauds the city's decision to keep police misconduct appeal hearings public. However, we strenuously object to the proposal to silence community input during hearings. Also, a number of provisions in the proposed panel configuration of the CRC will not help with the goal of speeding up the process. Furthermore, the previous proposal included promises of changes which are now absent. All of this proves we still need more time to hash out details, and the city should create a public work group to get this done properly. The public's ability to comment at hearings has been a strength of the CRC system. The implication that community comments will sway CRC to make a decision prompting the police association to file a grievance is speculation and insults CRC's ability to balance facts from opinions. Moreover, the appellant has not provided a paid advocate, while officers can engage a union representative and/or a lawyer at no cost. Volunteer appeals process advisors are warned not to advocate for the appellants and are not allowed to share the contents of case files with them. When volunteer attorneys connect with appellants, they are not allowed to look at the case files, and neither are the appellants themselves. Thus, the auditor implying the community should not comment because they don't have access to the case file is disingenuous. Community comments on training, policy, procedures, and history serve to improve the process. The DOJ did not recommend removing public comment in their findings letter or the agreement. Do not continue this effort to shut out the community. Disruptions to CRC and COAB meetings make it predictable that shutting people up will lead to more disruptions. Of 8 times officers have appeared at CRC meetings, there was only 1 time the committee proposed a sustained finding. Perhaps officers unduly sway the CRC. We only point this out to encourage a balanced playing field. The city is claiming sub-public comments have re-traumatized appellants. Of the 9 cases that have recently come before CRC, 2 appellants didn't show up, and so far 3 of the other 7 have said they were not bothered by public comments. Since the community regularly supports the complainant and wants the officer to be held accountable, the city's is a ridiculous claim. Lowering the quorum of CRC from 5 to 3 for appeal hearings will eliminate the value of the diversity achieved when selecting CRC members. We suggest that the city A, increase the CRC to 15 members, and B, use the 20-member police review board civilian pool to add to the panels. We suggest panels of 4 CRC members and 3 PRB members with a minimum of 5 present to proceed with an appeal. And if the city wants to really speed up the process, you should eliminate the conference hearings. The original ordinance resolved disputes between the Bureau and the CRC at a city council hearing. Rather than have the police come back to CRC, just let those appeals head right to council. In the last 2 years, CRC has met 15 times to consider just 8 appeals, in part because 3 cases were poorly investigated and because of 2 conference hearings. Then there are broken promises from the August 1st proposal. There's no longer a provision for CRC to use the standard of review preponderance of the evidence. And the CRC was going to be allowed to hear deadly force cases. There was also a promise to constitute a civilian majority on the Police Review Board. We appreciate that the complainant is now going to be able to come to PRB hearings. However, rather than just a representative, the complainant should be assigned an advocate from the day their complaint is filed. In summary, we ask you not to eliminate public input, to expand the CRC and utilize the PRB tool to a fuller extent. Slow this process down until it has been thought through. The few good things in the proposal do not offset the bad.
Before we go on, I want to make sure that, do you want to deal with responses at the end of the specific questions? Okay. All right. Okay. Next, we're going to have Peter Parks, and then following Peter will be Christina Malone.
I am Peter Parks. I work with a number of groups. I don't come as a representative of any of those, but I do work with the AMA Coalition. I also work with SURGE, Showing Up for Racial Justice, and other groups as well. So I am a concerned citizen. I read a lot of Dan Handelman's posts, and I agree with what Dan said just now. I'd like to second what he said. And I'd like to speak a few things that are kind of puzzling to me. One is the idea that citizens and complainants cannot give testimony in the review process. And I hear the collective bargaining agreement with the police as being a problem there. And to me, that's not a problem it shouldn't be a problem for us. We, as the citizens, are the ones who hire the police, and so we should have control over what happens with them. And there should not be parts of that collective bargaining that restrict what citizens can do to make their complaints very clear. And I come from a union background. I've been in 3 different unions. The latest was the Longshore Union, one of the strongest unions on the West Coast. And I believe very strongly in the power of the collective bargaining unit of agreements. But when you're agreement with a city, it's a little bit different thing, and it's not quite as clear who is the boss and who is the worker there. So I think it's a little different. So I'll just, in summary, I'll say essentially what Dan just said. Please don't eliminate public input at any level. Please expand the CRC and so that these panels can be larger and more representative of the community. Utilize the Police Review Board civilian pool to a fuller extent, and slow this process down until it's been properly thought through. Thank you very much.
Hello, can everyone hear me? I'm Kristen Malone. Sorry, closer. I'm Kristen Malone. I'm the CRC chair. If you all were present at the August 1st meeting, you would know that I was very opposed to the initial proposal for the consolidated board. I think there's a lot to be concerned about in the current proposal, but what I hear is that the city is tapping the brakes and trying to make a showing of some incremental progress, some good faith towards meeting the requirements of the settlement agreement. And so I guess while I hear a lot in Mr. Handelman's statement and in Dr. Silver's statement about the loss of a lot of things that the CRC has wanted and needed for some time, such as the ability to hear cases involving use of deadly force and officer-involved shootings, the ability to apply a preponderance of the evidence standard. I am more pleased by the idea that so much isn't being taken away from us, because I think that was the real fear with the timeline and the urgency that we were experiencing. I do have some questions that I hope we can get answered tonight. The first is that I don't really understand what's in this left-hand column of the diagram we have here. It looks like at some point there's a way that some complaints jump the line after the RU manager's review of recommended findings, go straight to discipline, and there's no loop back to a CRC appeal, and I just wanted to understand how that happens. And the way the diagram appears, it looks like we only hear things that come out of a PRB, which is not the way things currently operate. So I wanted to be clear whether this was an issue with the diagram or something that I wasn't understanding about code changes. I also wondered, because I didn't see it in the code changes, Ms. Osenak said that the most serious complaints get, I think the term she used was the full panoply of tools available, and so I was wondering if I am misunderstanding, and we are now able to hear the serious complaints about officer-involved shootings and use of deadly force. I don't see it in the code. And then another thing with respect to the public comment, I wanted to clear up. The way that the rule is currently redrafted, to me, makes very clear that we can't even take general public comment at the end of an appeal hearing after we have voted, that comment must be had at a separate meeting for general comment or specific issues, and that seems outside of the fact that we should have public comment on appeals, and that I hope that we can be afforded some credit that we are relying on what we should be relying on and reviewing the things in the file. And I suggested, I think, to the mayor's office at some point that if the real concern is that we're relying on something that we shouldn't be, we let juries hear things and they're instructed to disregard, and they're reminded of the standard that they need to apply and that they can. I have a few questions from the co-chair. Could I be allowed to read those in? Thank you. If I can find them. She asks, the issue of public interest still hasn't been addressed, I believe in reference to the Oregon State Employment Statute that has been discussed before. She notes that it's interesting that council isn't here. She asks why we are meeting to discuss these proposals if the changes have already been submitted. I think the question being, can we change this at all before the vote is scheduled? That's what I have. Thank you.
I think our intent was to wait until the end, but if it's all right with you, Dr. Haynes, because it's the CRC chairs, is it all right if we answer some of those questions now? Okay. So thank you all very much, both of the CRC chairs that are here. I know that you participated in the last town hall. You're here tonight. It is very much appreciated, and your ideas and input are essential to this process. So the first question, I guess I'll take them in reverse order, and I bet I'll miss one, but the question I heard was, is this a fait accompli? Is this, are there any changes? The answer is, as with every council filing, the intent is to...
Let me just because I knew we were going to have this meeting, and, so I was the one who drafted the proposed changes. So I knew we were going to have this forum, so these were put out to the public, so the public could comment on, and we could incorporate public comment. So this actually has not been submitted to council clerk yet, and I'm in trouble with council clerk and my boss because of that. But it's important that we get public comment. So I wanted to make sure that that was not left out there. Go ahead.
Yes, and I was going to answer that as his attorney so that he would not get in trouble with the council clerk. But yes, the answer is we are here to incorporate feedback. So the second is an update on the public interest test for whether or not a consolidated board could be opened up. The answer to that is still in process. We're still working on those options because it's a fairly complex issue. The other question that I heard is the confusion with the flow chart and putting these two documents together. The question is, did we intend to change the current process about what appeals CRC currently hears? The answer is no, we did not intend to change that. So to the extent the flow chart confuses that, it's confusion, not intent. And then your first question was about what is, I think Kristen's question is, what is this little box over here that says RU manager resolution discipline no review board? The answer to that is, again, that's not intended to be a change. That's the current process. So again, it's not intended to be a change. Do you want to talk about how we get there?
Yeah, under the current system, under the current version of the code, there's only a certain set of cases that actually go to a police review board. Under the code, any complaint where it's a proposed sustained complaint against the officer and the proposed discipline is at least a day off or greater, so it could be a demotion, proposed termination. Those cases under code automatically go to the police review board. Currently, any use of deadly force, in custody death, those cases automatically go to the police review board. I realize those may not necessarily go to a CRC appeal, but they go to the review board. Any complaint of bias, discrimination, harassment under city policy involving city employees, a complaint that an officer is engaged in those behaviors, that automatically goes to the police review board. The other category of cases that go to review board, which happens with a fairly high level of frequency, is in the review process. Once under the current system, the responsibility unit manager, the commander of a division or a precinct, makes findings. That is sent out for review by the officer's assistant chief, by the independent police review division, as well as internal affairs. And if they controvert, anybody in that process controverts the proposed findings or proposed level of discipline, that also goes to the police review board. So for cases where they're, well, let's say it's a lower level of discipline, lower than at least a day off without pay, where it could be a letter of reprimand or a command counseling with the officer. So again, typically those are going to be lower levels of alleged misconduct. If those cases, if there's a finding on that type of case, then the officer engaged in misconduct, but it is a level of discipline that is less than a day off, and it is not controverted by someone in that process, internal affairs, IPR, the assistant chief, those types of cases would not go to the review board, and they go straight to the officer's responsibility unit manager, their commander, for a disposition of that allegation of misconduct. If the officer gets if they get a letter of reprimand or get a command counseling out of that situation, it's going to go to the RU manager. It is not going to go to the review board, and it's not going to go potentially to the CRC for an appeal if it's a citizen involved complaint.
So I just a couple people brought up IPR or CRC's ability to investigate or review officer-involved shootings. So that's a creature of the collective bargaining agreement. So that is not something that the code prohibits. That's more of the collective bargaining agreement, as well as IPR's ability to compel officers and IPR's ability to discipline officers. Those three things are things that are in the collective bargaining agreement between the City of Portland and the Portland Police Association.
So hopefully that addresses, and I think the final question that I recalled was asking about, sort of a tying about the full panoply of resources devoted to that middle track. And to clarify, what I was referring to is specifically the IA and IPR investigation and review. So this first golden box, that is the that was a full panoply of resources that I was referring to in terms of the investigative resources that those two entities bring to the table and the amount of time that we're giving them to do the investigation, so that, as Mr. Handelman pointed out, we don't end up at the end of the process with folks saying the investigation, you missed, certain things. So, and I see Kristen, did I cover? Okay, thank you.
Yes, at this time we have the following persons: Carol Lansman, and T.J. Browning.
Hi. No, that's okay. Perfect. Hi, I'm Carol Lansman. I'm with Portland Cop Watch. And I think we all agree that the main purpose of all of this is to improve police accountability. And the best way to do that, as I understand from the research, is to have really good citizen oversight and review. And quite truthfully, listening to this conversation, I hear us rearranging deck chairs on the Titanic. We're not addressing... You're cutting into my time. I want all 3 minutes. We're not really addressing the main issues. Everything that we talk about seems to give less power to the Citizen Review Board. Why is it the Police Review Board gets 42 days on your little flowcharty thing, and the Citizen Review Board gets 22 days? Why is it that the Citizen Review Board looks at things with not preponderance of evidence, but reasonable person? I think that's almost a disrespectful standard. I hate that. God. We really need to get rid of first of all, the collective bargaining document shouldn't bargain policy issues. It's salaries, it's standards, it's benefits, but it's not policy. I'm just flummoxed, I say, that we can't have a citizen oversight of police officers who kill or maim or hurt because it's in their contract. I've worked for the public sector almost all my life, and they never said, so listen, if you kill somebody, don't worry, we'll let I'm a planner. We'll let other planners, I've never killed anybody, we'll let other planners look at it. I just think it's outrageous. We need a citizen review board. We don't need the police reviewing themselves. Okay, now, what I'm supposed to talk about from Portland Cop Watch, that was my own personal rant, although I'm sure many in Cop Watch agree, is that we support 7-member panels for review, 4 CRC members, and 3 civilian police review board people. Dan's excellent analysis shows that if there were 7 members with a 5-member quorum, it would be like 11 or 12 meetings for the CRC people and 6 to 8 meetings a year for the police review people. And there are 3 reasons for that. The first, of course, is, and the most important, is the most diversity, the better. Diversity helps in all decision making. And then another reason is that it wouldn't be too much work based on the numbers, and for the life of me, I forget the 3rd reason. But I'll tell you in a second. How much time? Well, you're already past. Oh, okay. Larger panels would this is large. It's a deck chair issue. Larger panels would decrease the possibility of having to call someone else in to review it, because oftentimes there can be 3 or 4 meetings on a panel. Thank you.
Okay, well, I just want to say ditto. Great job. I'm sorry, I'm T.J. Browning, and by this point, I just think all of you know me. wanted to address expanding the CRC to 15 members, although I like Dan's idea better. A panel of 5, it's diversity, it's workload, it's all those things. So I'm not gonna, I only have so much time. We need bigger panels, and that's the workload. I was a member of the CRC, I'm now on APA, which I'm understanding we're not going to have anymore. The amount of work that the CRC does is voluminous. I spend 10 to 12 hours easily per case, and I'm just a merely APA. So to have, there's a lot of work to share. They've got subcommittees, they've got hearings, they've got public out, they have all kinds of things. So the more hands to do the labor makes sense. We need bigger ones. Boy, did they throw the baby out with the bathwater in that first proposal, and trust me, that was a very small bath and it was a very small baby. But they gave us preponderance of evidence over reasonable person standard. I mean, what a small bone they threw us, and it's gone. What I don't understand is the Portland Police Bureau desperately wants to be, I sincerely think they want to be a professional police force. The citizens of Portland want a professional police force. And yet when they come before the Citizens Review Board, they are not judged on a professional standard, they're judged at what a reasonable person would do. Not a trained professional, a reasonable person. It makes it very difficult for the CRC, and it's incredibly frustrating to do what you think is the right thing for your community when you're bound by that kind of a standard. And I'm really, frankly, annoyed about the rush. We're Portland, and we may not be as weird as we used to be, but we're about citizen involvement, hearing people's voices, and it seems like this has systematically been an attempt to keep the voices out of this process. And it's not going to go away. If they succeed in this, we're not going to go away. Reverend, how long have we been asking for subpoena power? I say 20 years. What do you say? Yeah. How long have we been asking for independent investigation? Why is the citizens either going through IAD? Constantine has investigators. Why don't they just go directly to IPR to do the investigations? It's time, when we really should be talking about quality. Okay, here's what I want you to tell City Hall. Do not be worried about being out of compliance with the DOJ. Be really worried about being out of compliance with the wishes of the citizen of Portland.
Yeah, I'm going to ask you for just a moment of silence. Our president of the AMA Coalition just lost his sister, and he had to leave at this time, the senior pastor of this great congregation, Maranatha. Would you please honor us with just a moment of silence? Thank you very much. Okay. At this time, we will continue the forum. We're having Debbie Iona and Wally G. Barnett.
I'm Debbie Iona, sorry. Representing the League of Women Voters of Portland. Can you hear? Okay, good, thanks. So thank you for the opportunity to offer our thoughts on the auditor's proposal. As an organization that promotes active and informed participation in government, we recommend that a work group or task force be appointed with CRC and COAB involvement for the purpose of considering a variety of options for improving our oversight system. It could analyze the investigative process and propose solutions that address the problems. The work group meetings should be held in public. The auditor's proposal is an improvement over the last one, and we fully support continuing to hold CRC appeal hearings in a public setting. Other features we support include all complaints of officer misconduct will be investigated. Recommended findings would be drafted by IPR and or IA depending upon which agency completed the investigation. The complainant would be allowed to attend police review board hearing and make a statement, although more thought should be given as to how to support the individual in light of the potentially intimidating nature of a hearing room dominated by police bureau officials. We disagree with other provisions. As longtime observers of the CRC, we see no reason to eliminate public comment from appeal hearings. The CRC members are carefully selected and trained and have the capacity to filter out comments that are not factual or relevant. Appeal hearing panels should have more than 3 CRC members on them in order to ensure diversity. A priority was placed on a diverse CRC, and it is written into the ordinance. Adding more members to the full CRC or pulling in police review board members for hearings would provide the capacity needed for larger panels. If the primary goal of these changes is to speed up the process, it would be extremely helpful if IPR or the Bureau provided an analysis of recent cases so city officials and the public could see where the holdups actually are. We also would encourage consideration of eliminating the conference hearing that occurs when the Bureau disagrees with the CRC's recommendation. This was not part of the system at its inception and was added with no public discussion. It is sometimes time-consuming for the chief to decide if he disagrees and then to schedule the hearing. It would certainly save time if those cases went directly to City Council for resolution. Again, please create a work group that can work collaboratively with the public to propose solutions that meet the community's needs. And then I just have, I have a few questions. Can I get them on your list? Okay, number one, how many times have cases gone to arbitration because public comment was taken at appeal hearings? Why haven't city council members appointed their representatives to the COAB? And are you really eliminating the APA, as TJ mentioned? Thanks.
My name is Wiley G. Barnett. I'm over 40-year resident of Northeast Portland. So I've seen a lot of dynamics come and go and a lot of concerns that the community has had. In terms of making my comments very brief, I just want to reiterate and support people who have spoken before me, because I agree with each of the comments that's been made before. I have two things that I'd like to bring up or bring notice to, and actually, if at all possible, have a response when the time comes from the panel. Given the fact that, as you have already heard tonight, so many of the most critical issues that are involved in the whole process of trying to seek justice for complainants, there are items that are scuttled off into the union contract. That should not be. But also, further than that, I'd like an answer is it true, from what people in the community seem to be saying, that as a matter of fact, the mayor is already under discussions with the union to begin to discuss the contract even a year before the contract is to be completed? And we need, if we're going to have any justice or any fairness or any truth in this current process right now here tonight, and the subsequent things that are going to pass as far as the city council, to what extent will the things that a lot of the people here are already concerned about get washed away in whenever the contract does come due?
Let us continue to go forth as Sue Bartlett and Philip J. Wolf following Sue.
Hi, my name is Sue Bartlett. I'm not affiliated with any of the organizations, but actually one of my questions is, louder? One of my questions is the same as Mr. Bernard's, or similar. So the collective bargaining agreement seems to be at the crux of the fairness and accountability issues. So why is it being negotiated now in secret with the current mayor, who, as outgoing mayor, has no political skin in the game? I'm trying to understand what is the point, what the point of public comment is if it happens after the decision is made. I'm sorry, I have trouble with that logic. And I'm wondering, how does this plan, I mean, there's lots of moving parts in it, and I understand they're trying to make it better, but I still don't understand how this plan increases police accountability in any way. And perhaps rhetorical, why are the police so afraid of transparency?
So I get to have a little bit more time because I'm signing and I'm going through an interpreter, so just to say. So I'm Philip Wolf, and I am on the COAB Oversight Board, and I'm here as a citizen tonight, a concerned citizen. So two things I would like to say. I am very much in support of Dan's statement. I agree with everything that he said, 100%. And I hope that the panelists will listen to his statement. And I feel that citizens definitely have a right to have input if they have filed a complaint and be able to be involved in the process.
Just like if a person was in a restaurant and wanted to complain to a manager, the same thing would happen, and you would be able to get a free soda or a free meal or something to make up for it. We want that kind of oversight here.
And so, along with that, if somebody makes a complaint against an officer's behavior, we need to have accountability on both sides, so that I encourage that the police be required to, I think that an apology would be nice if we're talking about low-level grievances. Some sort of something, an acknowledgement to the person who's making the complaint. And also that those, whatever needs to happen as far as traveling up the chain of command to somehow make it up to people what they've experienced. Because there, and then for further, grievances that are of more serious context, like police brutality and such, of course we need to have more serious action taken. And of the issue of having reduced membership in the oversight committees, there is a lot of work that goes into the responsibility of those committee members of the CRC. And I think that we should have 5 members or more on those panels. And because what if somebody gets sick? What if somebody moves? People have life experiences that cause changes, and they, then maybe they leave the committee. And so we need to have enough members that they can function adequately. So please consider that. That's a very serious issue, is having enough members to also just spread out the workload. So thank you.
And as we continue to move on, the two following speakers will be Teresa Rayford and Judy L. Ramos. Is that correct? Okay. And Ramos want to make note that she was speaking for Dan Silverman in the first time. Okay.
All right, and I'm speaking on behalf of members of Don't Shoot Portland, which is a community action plan. And I just want to second that I do support all of the directives that were included in the Portland Cop Watch statements. Dan Handelman does attend damn near every meeting that happens to be around police accountability. His team does the research, and they have the know-how, and so we all should be thankful that we have an organization out here that does push us forward, but also works on research that is available to all of us when we connect with them. So I do support those movements. Also, I just wanted to say that as somebody that has made and filed complaints, not only for myself, but with family members through this process, that some of the biggest issues with the time of the process is the ineffectiveness that's included in the process. There's not a lot of power for the CRC, and then the IPR and the way that it works with the Portland Police Bureau, knowing that the power is mandated in the collective bargaining agreement, only shows us that the phraseology that's used to exonerate these officers is why we have so many dismissals that are not sustained. That's a violation not only of delaying a process of justice, but it's a violation of the civil liberties of the people that think that they're using a process that would actually help them obtain justice. So some of the things that have happened when we've used this system and we've been denied justice and we've had justice delayed, which has denied further justice, is that we've used the system through the appeals process so that we could prove out that the phraseology is which is used against us to exonerate. That is working through our auditor's office. It's very sad that Daryl Turner, the union president, is the one that told us that we have no political will behind our commissioners in regards to the collective bargaining agreements that mandate these type of relationships. No political will from our mayor or any of our elected commissioners. The mayor is the commissioner, the police commissioner. He should be at these meetings. It should be mandated. It should be mandated. When people come through, not only should the APA remain, but there should be legal power within that system of appointed leadership or appropriate advocacy for the people filing these complaints. To show up for an appeals hearing, not understanding what's in the written language that everybody has been able to use in order to make their statements, and not even to have any of that available to you, not even to have someone that can explain it to you. That's on purpose. It's written, it's mandated, it's part of the collective bargaining agreement. It violates your civil liberties. I think that we should all ask for a serious audit of these processes, and in regards to the CRC, I appreciate everything that the volunteers are doing on that board, but they need more power, and we shouldn't be asking or accepting our city taking away power from these bodies. We should be demanding that they have more and that there is less city involvement, because it is a violation of our civil liberties. That's what I found to see.
Hi, my name is Julie Ramos, and I'm speaking for myself. I just have 3 quick points. One is slow down, please. I think something so critical, important. As a CRC member, I've spent a lot of time and energy working towards police oversight, and it frustrates me to no end to just like have this be rushed through. So please slow down. 2, I agree that part of the richness of the 11-member board is the diversity, and I don't think a 3-member panel is adequate. And my last point is just, I get a little, I don't know what the word is, when I look at this whole process, the 188 days and this 21 days allotted for what I feel like is the most important, that is when the public actually has a voice in the process. So I mean, I could cut some days from other places, but I think it's really critical that, one, this process not be rushed, and the CRC's appeal process not be rushed. Thanks.
At this time, we'll hear the responses from the panel.
First of all, I want to thank everybody for your candor, your thoughtfulness. I think we've clearly heard some themes that Ms. Ramos summed up, which are essentially we're getting feedback from you all that you would like to slow this process down, and that you want to think more about the proposal. So I think we've heard those things loud and clear. The questions that I had outstanding, and I'll go through these, and then was, I believe Ms. Ione asked, how many times has a case gone to arbitration? Essentially, I understood your question to be, has the city actually experienced the harm that that might result from allowing public comment into a case that's currently being adjudicated? Marking is that, but the short answer is no, we do not have an example for you where that has happened. Part of what we do as city attorneys is to evaluate in a neutral way, applying the breadth of our experience. And so what our legal advice is that though the city, in the limited number of CRC appeals that have occurred over the last 10 years, the harm has not manifested itself in an arbitration, our legal opinion is that it certainly is a risk, one that is particularly speculative. Again, that is a risk that we have incurred throughout the time that CRC has been in existence. So I think the second one was a question and comment about the COAB. Go ahead.
I'm sorry. If I could just expand on that last point very briefly. Again, we're looking at this from this is an overall system of which CRC is an important part, but it is part of an overall system. And we, fortunately, up to this point in time, have not had serious officer discipline cases going in front of CRC. I mean, they're all important, obviously, but if we have a very serious case that goes in front of CRC, I'll say from our perspective, we are concerned about. We're looking. I think everybody's in agreement. As somebody mentioned, that everybody in this room is looking to have an effective police accountability system. I don't think there's any disagreement about that. And from our perspective on that, we look at if an officer through their union files a grievance over discipline, it goes to an outside party, a labor arbitrator who's going to hear that case. And if the officer has not been given what the arbitrator believes is procedural due process, a fair process, we run a significant risk that an arbitrator could overturn that decision, which in terms of having an effective accountability system is not a good thing to have happen. We've had other cases, which I believe the public is aware of, where the city has taken actions when there has been serious, from the city's opinion, serious police misconduct, and arbitrators have overturned those decisions, and it creates that's going to happen. That's the system, but it creates, in our view, and it reduces the effectiveness of the system. So I just want to point that out because we are taking that into account when we're considering that particular issue.
When have we ever won an arbitration? An officer kills somebody, the mayor wants to fire him, he's reinstated. We've never lost an arbitration. We've never been able to fire anybody. And you're afraid that the citizen body might get overturned?
So TJ, we were asked what our legal opinion is, and we are telling you, I understand you disagree with it, but our responsibility to you as citizens and to people who are here is to answer the question. And what we were asked is, I believe, is there a legal risk in having individual cases where the public is allowed to comment to a body who is recommending a result in an individual discipline case? Is there a risk in allowing a member of the public to express their opinion about how CRC should vote? And our answer to that is yes, there's a legal risk, and as many people have pointed out, the legal risk does not necessarily need to drive the policy decision, but it's our responsibility to you and to our clients at the city to give you straight information about whether or not the risk exists. It does, but it doesn't necessarily need to drive the policy decision. So the next question that I heard was about the Community Oversight Advisory Board, COAB, which is under the settlement agreement, and what is the city doing about that? Those are great questions. This is not the forum where we want to have those particular discussions. There is a sign-up sheet because, again, the AMAC has been I cannot say enough nice things about their willingness to host, and they are hosting a meeting over the next 60 days. The city will be engaged in a process of figuring out how to have effective community engagement in the settlement agreement, and I believe September 12th. And then there's been a request to provide daycare. I know that's being taken into consideration, but on the 12th, that's another opportunity where we very much like to hear from people about that aspect of the settlement agreement. The next question is in reference to Ms. Browning's saying that it appears that the advice and assistance that's being currently provided to complainants is no longer going to continue.
So the plan is to maintain the current system of providing an APA, and the appellant and the APA would still be able to participate in their current roles in the proposed model.
So I think that was my understanding as well. There was not an intended change there, and I appreciate that feedback because we want to go back and look and make sure that we didn't make an unintended change. The next question is from a couple of people asking about the current status of discussions involving the collective bargaining agreement. Again, totally understand where those questions are coming from. The truth is that in terms of the current proposal on the table that we're discussing tonight, the collective bargaining impacts, if any, are something that we're looking at, but at this point we are not proposing changes to the collective bargaining agreement as a result of this current proposal. So that is the short answer to that, but message received that there is, what I'm hearing, a lot of concern around those talks being secret or wanting more information about what those discussions are about. And then the final question I heard, and I've heard this a couple of times, in terms of the timelines and why it is that the CRC appeals only have 21 days. There's a short answer and a long answer. The short answer is the settlement agreement that we negotiated with the Department of Justice specifically set forth some parameters under which both the city and the Department of Justice wanted to have the CRC function, and one of those was to resolve appeals within 21 days. I think from the very beginning, the city certainly understood that that was an ambitious goal, one that that we needed time to see whether or not we could achieve. The one, again, as your attorney, what I need to tell you all is 21 days may not seem like a lot. The current number of days that these appeals are taking is in excess of 120 days. I'm not placing blame on anyone. I am simply telling you what the facts are. And one of the things that that I asked and that the city really needs to hear from you all, I think it's very important for us to hear what you don't like about the proposal. What I am asking you all to do for me is that you are both citizens who receive police services, but you are also the employers of police officers. And I know from talking to many of you that it is important that the accountability system be something that officers, those who are participating in the system as people having complaints filed against them, that the process is fair to them, but also that they feel there is credibility in that process. And so part of what we're struggling with is I need to understand from you all whether or not, if the maximum time, if we say CRC is the most important process, and if it takes 140 days, which would put our entire discipline system at approximately, what is 180 plus 140? I went to law school, so I don't do math. 320 days to resolve an appeal. I find it very difficult as the attorney for the city to say that that is a process that is either comports with national best practices or is really what the citizens of Portland are saying they think is a fair and expeditious process. And so I need to go and have a discussion with the rest of city council, with the elected officials, and I need to understand whether or not what you all are saying is, we do not care how much time it takes. CRC should get all the time in the world, and if it takes 300 days to resolve a complaint, that's the way it should be. If that is, that's really what I'm hoping to get feedback from you all about. And the rest of the feedback that we've gotten is very helpful. And again, I think what we're here to do is to take that feedback and look at the proposal that we have and see where changes can be made.
We have two last speakers, Edward Hershey and Joe Walsh.
Good evening. I thought I was signing up to speak, and I turned out I was signing an attendance sheet, I guess, which is why you're hearing me after you answered the questions. When I arrived in Portland 11 years ago, one of the things I found very weird was a city government system in which the same 5 elected officials made the laws, enforced them, and pretty much had oversight over each other. And I thought that it was most unusual in the police bureau, because here are matters of life and death. So when the prior auditor wrested away control of the review process from the political process, I volunteered to be part of that pool that is described. I have spent 6 years, 2 consecutive 3-year terms, and I cycle off. I'm term limited. This month, I've participated in 20 sessions, most of them very interesting. I wish I could tell you about them, but unfortunately, they are matters of secrecy. Not only are matters of secrecy, but I'm not even sure how many times the recommendations that we made were approved by the chief, because I'm shown once a year, I'm shown a summary sheet, and I have to leave it in police headquarters. I'm not even allowed to take that. So transparency is not part of the review process when it comes to the public. I understand why. There are HR issues involved and confidentiality. I am, I think, legally allowed to tell you about the structure of these boards and to endorse heartily what I read as a change in these proposals. There are 5 members. 2 of them are the commanding officer of the officer involved, and then his or her commanding officer. The 3rd one is a peer. So 3 of the 5 members are sworn officers. The other is a member of Constantine's office, and the 5th is a citizen panelist, and there are 2 of us if it's a use of force case or another serious case. Up until now, the 2 commanders, the brass, who are voting members of the panel, are also presenting their findings. They're effectively voting on their own findings. That's going to change, as I understand it now, in the new system, which is a change in the right direction. 2 or 3 times in these 20 times that I participated, I actually convinced a couple of these people to change their findings. And I wish I could tell you about those, but I can tell you the importance of transparency. And so I understand, although I have no experience with the CRC, I understand both the frustration expressed here today as well as the need for transparency in other places if by law it cannot be in the actual hearings and executive sessions. Let me just add one other thing. I started a union at the newspaper I worked at in New York. I spent the last 5 years of my working life here in Oregon as the communications director of SEIU 503, the largest union in Oregon. I think blaming the collective bargaining agreement, which the city itself initiates and bargains with the PPA, is disingenuous. If you have to buy some of those onerous positions, buy them, just like you're in the process of buying the 48-hour rule. Thank you.
My name is Joe Walsh. I represent Individuals for Justice. I would echo everything that Dan from CopWatch said tonight, and I hope this panel takes it to heart. They won't. One of the problems that we run into all the time is we come into the system too late. People have spent hundreds or thousands of hours working on a project, and then they call for public input. What do you think the probability is that the city council or this group is going to overturn all that work just because we don't like it? Just because the citizens that come and ask them, don't do it. We monitor City Hall every week, except tomorrow because there is no meeting. And every issue, or 99% of them, that we oppose, they vote for. I call it the pirate sound. I, 5 times. They sound like pirates to me. Everybody seems to want clarity. Everybody seems to want transparency. Everybody seems to want to do a good job. It's all words. Coming from this city, it's all words. 12 years to try to get an independent person to look at what the police do to their citizens. 12 years, think about that. 12 years of standing up here, running out of breath for us old folks. Why is that so? And the last time I got arrested, I did not say to the police officer, hey buddy, you work for me. I said yes sir and no sir a lot. When they put handcuffs on you, you say yes sir and no sir. I got arrested a month ago, and then I got arrested 7 years ago. Nothing has changed. Nothing. The police are jerks. Understand that. It's not a bad few apples. It's a few good cops. That's the problem. And until we understand that, we look at the reverse. We say, oh, it's just a couple of cops don't know what they're doing, shouldn't be there. No, the whole system is corrupt. From top to bottom. Getting rid of the chief, not gonna work. We've done that. The whole top level of the police department has to go. The entire top level. And we need to recruit people out of Portland that want to live here, that want to work with us, and that want to listen to us. Until that happens, we're going to keep coming, and I'm really getting tired. And thank you, Kay. I think I went over.
Thank you, Joe. And this will be our last speaker, Christina Neves.
Good evening, everyone. Can everyone hear me? Great. Okay. Good evening, everyone. I'm from Commissioner Amanda Fritz's office, and I have a comment from her to read. I am out of town on a pre-scheduled family vacation trip. I am so sorry I cannot be there tonight. I remain deeply committed to the DOJ settlement agreement, police reform, and improved community safety for all. We might need more citizens, perhaps, on the CRC involved with a peer review process. We hope that this is the opportunity for community input that can yield a helpful compromise. Thank you.
First of all, we want to thank each of you for coming out. Let's give yourself a hand. And we want to thank this panel. Let's give them a hand for having the courage. Okay. We want to say that some important factors have been brought out here. I think Dan, who's also a member of our executive committee of the AMA Coalition, has brought some, and many of you have brought major points out. But the fact that accountability is an essence of trust. Without accountability, there can be no trust from the community and carrying out the responsibility of policing our community. And so we have to get this piece right. And if it means slowing down to get it right, we have to slow down to get it right. But whatever it takes, it will not go away. The French author and writer Victor Hugo said that there comes a time when an ideal time has come. Nothing in heaven and earth can not stop it. The time for police accountability is right now, not later. Thank you very much. As Dr. Belter often say, the struggle is not made in moments, not in miles. A movement is continuous. And this is a movement, and we hope that others will join this movement for the long haul. It's not going to move in just a month. It's not going to move in just a year. It takes sometime, even a lifetime, to move a nation. But whatever it takes, we must have the commitment, we must have the courage and the faith to continue. Thank you very much.